Hello, 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 dear students. Am I audible? Am I visible? Can you all see me? Yes. Who all are there? Please mark your attendance. My dear Avengers, kindly assemble. Dear Avengers, kindly assemble. Dear Avengers, kindly assemble. Avengers, assemble. Avengers, assemble. Where are you all, my dear, lovely, lovely cuties and dear students? Where is everyone? Where is everyone? Okay. So I hope everyone's here. Who all have come here? Wow, so many students watching live. I am so happy. And tomorrow is the day of result of CS Executive as well as CS Professionals. So the students who are, awaiting for the result, I pray to God that you get the result that you want. Good afternoon, Selvi. Good afternoon. Long time no see. How is everyone? Is everyone doing good? Is everyone doing good? Yes. Very good. If you have come, then please do not forget to like the video, and also subscribe to the channel because it takes nothing. Just one like. That's it. Yes or no? Yes. Sure. So today we are going to complete the remaining questions of Indian Contract Act that we were supposed to solve. In the last lecture, if you remember, we had solved around approximately 1, 2, 3, 1, 2, 3, 4, 5, 6, 7. We had solved 7 questions in the last session. Today we are going to start off with the first question of the day, and that is difference between fraud and misrepresentation. So we are going to study about what? Fraud and misrepresentation. This question was asked in December 2022 for how many marks? 3 marks. This question was asked in exam for how many marks? It was asked in exam for 3 marks. So let us start with fraud and misrepresentation. Fraud means, what is the meaning of fraud? Now see, basic difference that we all know is that fraud happens intentionally. Misrepresentation is a false statement, but it was not done intentionally. In both the cases, you are doing something wrong. You are saying something wrong, which is not true. But in fraud, you know it is not true. In misrepresentation, the thing is, you think it is true. For example, I have a factory which makes biscuits. So we'll first understand the basic of fraud and misrepresentation so that you all will be able to understand the basic, bare minimum difference between the two terms. Okay. Now, first things first, my dear students. First things first. Okay. First, see, I have a factory which makes, let us say, biscuits. My factory makes biscuits. And to make the biscuits, we have a machine. Okay. This factory belongs to me. You come to my factory. This is you. You ask me a question. And that question is, how many biscuits are made? How many biscuits are made daily? So what is the question that you have asked? How many biscuits do you make using this machine on a daily basis? Now the question is, how many biscuits are made by my factory on a daily basis? The real number is 6,000 biscuits. What is the real number? 6,000 biscuits. The real number is 6,000 biscuits. Now, I say we make 25,000 biscuits. Okay. What is the real number? 6,000. But what did I say? That we are making how many biscuits? We are making 25,000 biscuits on daily basis. I said this with knowing that it is not true. I knew that this statement is not true, but I want you to purchase the factory that I have. I want you to buy the factory that I have. So in order to sell the factory, I did this. Now my question to you all is, was I aware about this statement being false? Yes, I was aware about this statement being false. But still, did I tell you that it is true? It is true. Yes. I was aware. Yes. But I said that it is true. This is a case of fraud. This is a case of fraud. I induced you to enter into a contract. How did I induce you? I induced you by giving a statement which is not true, but you thought that it is true, and that is the reason why you entered into contract with me. I hope you have understood this. But on the other hand, when I talk about misrepresentation, in misrepresentation, the scenario is totally different. This is my factory. I have a machine in my factory. Okay. I have a machine in my factory. This is me. This is you. Okay. I tell you, you ask me a question. How many biscuits are made? How many biscuits are made? I give you the same number, but this time I am innocent. I think that what I am saying is true. See, the real manufacturing of biscuit that is happening is 6,000 biscuits are being manufactured on a daily basis. But I said that we are manufacturing 25,000 biscuits, and I thought that this is true. Is this a case of fraud? No, this is not a case of fraud. This is only misrepresentation. So can I say that in fraud there is misrepresentation plus there is mens rea, which means guilty mind. Do you understand this, my dear students? Did you guys understand this? Did you guys understand this? And if you have understood this, what is stopping you from liking the video? I mean, what is not making you like the video? Yes, is this clear? Is this clear to everyone? First, base is clear. What is the difference between fraud and misrepresentation? Very good. Now, if you have understood the basic difference between fraud and misrepresentation, let us understand it in detail, step by step. Fraud means suggesting a fact which is false. Suggesting a fact which is false. And this fact you have suggested knowingly. You know that it is a false fact, or you are hiding a fact, which means you were supposed to say something, but you are not saying it, you are hiding it. Okay. Or fraud includes a promise you made without the intention of performing it. You know that you will not be able to perform, but yet you have made the promise. Or any other act or omission declared fraudulent by law is fraud. So, sir, what is the meaning of fraud? What is the meaning of fraud? Fraud means you know that you are suggesting a false fact. What is the fact? 25,000 biscuits are made. Is it a true fact? No, it is a false fact. And do I know that I'm saying a lie? Yes. Okay. So what is the meaning of fraud, everyone? Knowingly suggesting a false fact or hiding a fact. I know that the goods are defective, but I'm trying to hide that fact from you. I'm trying to hide that fact from you. That will also amount to fraud. Or I make a promise without intention of performing it. Without intention of performing it. Okay. I know that I'm making a promise, but I know that I will not be performing it. So I'm using the different color. Promise made without the intention of performing it. Okay. So what is the meaning of fraud? Red color, suggesting a fact which is not true. Green color, hiding a fact. Yellow color, you made a promise without the intention of performing it. And last is any act or omission which is declared fraud by law. Any act that you do which law says is fraud will be treated as fraud. Will be treated as fraud. I hope you have understood the definition of fraud. And what is misrepresentation? Statement which the person is making it honestly because he believes it to be true. The statement that I made, I believe that the statement is true. Okay, so what is the meaning of fraud? Suggesting a fact which is not true, hiding a fact, or promising and you know that you will not be performing the promise. And what is the blue color line? Any other thing that is declared fraudulent by law is fraud. What is the meaning of misrepresentation? You are stating something because you think that what you are stating is true. You are believing that your statement is true, but in reality it is not true. Is this clear? Is this clear? Now, in fraud, you have a deliberate or a willful intention to deceive. Okay, you have a clear intention of deceiving the other party because you want the other party to enter into contract by hook or by crook. Okay, but in misrepresentation, it is an innocent wrong. You don't intend to deceive. You want that party to enter into contract, but you are not intending to deceive them. Okay, then comes the third point, belief. You know that it is not true. You do not believe your own statement, but still you are giving that statement. On the other hand, misrepresentation, you believe it to be true, you think that it is true, or you don't know what you have said is false. Remedy. If fraud has happened with you, you are an aggrieved party, you can claim damages, also you can cancel the contract. Okay. But in misrepresentation, you have the right to avoid the contract without claiming for damages. You can cancel the contract, but you cannot claim damages because over here the party was innocent. Nah? He said something because he thought it is true. So you cannot claim damages, but you can cancel the contract. Punishment. In certain cases, there will be punishment for cheating under IPC, now called as Bharatiya Nyaya Sanhita 2023. Okay. But this right here, misrepresentation, is not a criminal act, and that is the reason why it is not punishable. Is this clear to everyone? Is this clear? Is this clear to everyone? Is there any doubt? Very good. Now, let us go ahead and let us understand the next question. So the conclusion is fraud involves intention to deceive the party, where misrepresentation is made without such intention. In fraud, you have intention to fool the other party, but in misrepresentation, there is no such bad intention. Is this clear, my dear students? I hope this is crystal clear and there is no doubt to any one of you. Yes or no? Now, question asked in 2021 for 4 marks. Question asked in 2021 for how many marks? 4 marks. Oh, oops, you cannot see the marks. Yes. Promise is made by father to give 1 lakh to daughter. Now, please tell me, according to you, is this enforceable in court of law? Father has promised to his daughter out of natural love and affection to give 1 lakh to his daughter. Can the daughter recover the money because there is no consideration over here? But I think it falls in the exceptional case. Do you think it falls in the exceptional case of no consideration, no contract? If the answer is yes, then please tell me what are the conditions for it. Yes. Father has promised to give 1 lakh to his daughter out of natural love and affection. Okay. Okay. Selvi says yes. Now listen carefully. F promised to give his daughter D 1 lakh out of natural love and affection. However, the promise is not in writing and it is not registered. What is the provision of Indian Contract Act? Indian Contract Act says no consideration, no contract, but there are certain exceptional cases, and first exceptional case is promise made out of natural love and affection. The first exceptional case is promise made out of natural love and affection. But when a party makes a promise out of natural love and affection, remember one thing, it has to be with a person who is in relation to him. Also, it should be in writing, and that written document should be registered. That written document should be registered. Now over here, we know the provision that consideration is an essential element of a valid contract. Agreement without consideration is generally void and is known as nudum pactum. But Section 25 gives exceptional case that an agreement without consideration is valid if it is expressed in writing and registered. If it is expressed in writing and registered, it is made because of natural love and affection, and the parties are in near relation to one another. Now, see, as a thumb rule, consideration is essential element of a valid contract. Okay, agreement without consideration is void. This is the provision that you will write. Section 25 gives exception that agreement without consideration will be valid if it is in writing plus registered. It is in writing plus registered, made out of natural love and affection, and parties stand in near relation to one another. Is this clear? So in this case, it is made out of natural love and affection. Yes. The parties are in near relation to one another. Yes. But is it in writing? No. Is it registered? No. If it is not in writing, how can you register something? So tell me one thing. F made a promise to his daughter D to give 1 lakh. Okay. However, it is not in writing and registered. Although father and daughter are in near relationship and the promise is based on natural love and affection, the promise is not in writing and not registered. Therefore, D cannot legally enforce the promise against her father. Is this clear? Is this clear to you all? Is this crystal clear to all the students who are watching the session? Doubts? Easy peasy, lemon squeezy, easy question, my dear students. Doubts? No doubt, no question, no query. Concept is clear. And men, please like the video. So many of you are watching. What is the wrong? Is the with you? Okay, now. Look at the fact of the case. This is the question. Okay, now I want input from you all. Okay, look at the fact. John is a known minor. John is a minor. He has fraudulently overstated his age. He took delivery of a motor car and made a promissory note in favor of the dealer. He does not pay the price of the car. Now, what has happened over here? Let us understand it with one example. Let us understand this with one example. Okay. This is Mr. J. This is Mr. J. He is a minor. He is a minor. He lies about age. Lies about age to a car dealer. Okay. Now the car dealer is supplying car to him. Now the minor, is making a promissory note. In whose favor? He made this promissory note in the favor of car dealer. So, number 1, the minor lied about his age. Number 2, he got the car. Number 3, he made a promissory note that I, minor, will pay the money to you on so and so date. Are you all with me till here? Are you all with me till here? Did you all understand the question? Did you all understand the question? So, A, Mr. J lies about his age to car dealer, takes the delivery of the car, makes a promissory note, and does not pay. Can the car dealer sue Mr. J? Can the car dealer sue Mr. J? Because he has lied about his age. Does the car dealer have any remedy against the minor? Please give reason for your answer, my dear students. Please give reason for your answer, my dear students. Can the car dealer sue and recover the money from Mr. J? I want reason, I want provision, I want a reason for this. I just don't want yes or no, I want a reason for your answer. Why yes or why no? Why? I want reason. I don't think so. You have studied law properly, everyone. If you have studied law, if you would have studied law, you wouldn't have made the silliest mistake of all time. Everyone, please look at the screen. An agreement with a minor or by a minor is void and inoperative, and it is ab initio. Agreement with a minor is void ab initio. Agreement with a minor is void ab initio. Yes or no? Where the transaction is set aside as void, the court may direct the minor to restore the property to the other party. The car owner cannot recover the amount of promissory note because the agreement with the minor is void. If the minor has signed the promissory note, can he recover the money? No. However, on equitable grounds, court can order minor to return the motor car if it is still with him. Thus, motor car dealer cannot recover the amount of the promissory note but can recover the motor car if it is still with the minor. Is this clear? Is this clear? Is this clear? Is this clear? Now, the same question has been repeated. See, the question was asked in June 2019 for 4 marks, June 2018 for 5 marks, December 2022 for 4 marks. One question asked multiple times. And minor can always plead minority. Minor can always plead minority. Is this clear? Also, if we go by the judgment of Mori Bibi versus Dharmodas Ghosh, rule of estoppel is not applicable on, rule of estoppel is not applicable on minor. All minor can always plead minority, and also specific restitution of property. Minor, you cannot ask the minor to give the property, but yes, on just and equitable grounds, the court can ask the minor to deliver back the property that he has purchased by fraudulently inducing the other person by saying false age. Is this clear? So can you see the question has been asked for 1, 2, 3 attempts? The question is asked in exam twice. Is there any doubt? And so many of you are watching. I repeat again, what is the problem for you to like, man? Why can't you like it, man? Okay. Now, one question is asked, what is the meaning of agreement in restraint of trade? Asked in June 2014 for 5 marks, June 2016 for 5 marks. Agreement in restraint of trade. What is the next question? Agreement in restraint of trade. Section 27 says that every agreement where you are stopping someone from exercising a lawful profession, trade, or business of any kind is void. Any agreement which stops a person, I repeat, any agreement which stops a person from exercising lawful profession, trade, or business of any kind will be treated as void. Will be treated as void. Is this clear? But there are certain exceptional cases where certain restrictions by agreement are allowed. Okay, there are certain exceptional cases where such agreements are treated as valid agreements. Number one is employment agreement. Number one is employment agreement. Everyone. If an employee is agreeing to serve a particular employer, if one person is saying that I will only work with you for a certain duration and not work for anyone else for that period, is a valid agreement of restraint of trade. I mean, this restraint is allowed. This is not invalid. Blue color says that if you put any restriction on any person from performing lawful profession, trade, or business, is void. But there are exceptional cases where the agreements are valid. First is this point. First is this point. Is this clear? Okay. Second, sale of goodwill. Second is sale of goodwill. What is the meaning of sale of goodwill, everyone? Sale of goodwill means if I am a seller of goodwill. For example, I have a big brand name. Okay. If I sell that brand name to you, you will tell me that Shubham Joshi, promise us one thing, that you will not copy the brand name. I repeat myself again. If I am selling a goodwill to you, I am selling the brand name to you, you will be like, Shubham Joshi, thank you so much for selling that goodwill to us. We are obliged, but promise us one thing. You will not use the same brand name in a particular local area for a particular period of time, or you will not start same type of business in the particular local area for a particular period of time. So if I make such promise, such promises are valid, but the restriction has to be reasonable. The restriction has to be reasonable. I repeat myself again, where the seller of goodwill has agreed not to compete with the purchaser. I am selling my goodwill to you. I am promising that I will not start a competing business. It is enforceable if the restriction is reasonable. If the restriction is reasonable and it is limited to some territorial limits and limited to a length of time. What is the meaning of this? In your area, I will not start the similar business. That is allowed. Such restriction is okay. In your area, I will not start the similar business. It is okay. But I sold my goodwill to you in Coimbatore or Chennai and I want to start the similar business in Ahmedabad, Gujarat. Is that allowed? Yes, that is allowed. That is not invalid. That is not treated as invalid. Is this clear? Such restrictions can be imposed. Such restrictions can be imposed. Is this crystal clear to everyone? Is this crystal clear to everyone? Okay. Now, restriction on existing partner. Okay. Now, If it is a partnership firm, we can add in our partnership agreement, partnership deed, that a partner will not carry any business other than that of firm while he is a partner. If you are partner with us, promises that you will not carry on any business which is similar to partnership firm's business. Such restriction is also allowed. It is not invalid. Then restriction on outgoing partner. You were a partner with us. You are leaving the firm. We can put a restriction on you from carrying similar business with specified period or limit, provided restrictions are reasonable. What is the meaning of this? I can put some limit on you. I can put some limit on you with respect to when you will start. I can put a restriction on you with respect to in which area you will start the business. Such restrictions are allowed. So we saw 4 restrictions. Number 1, employment agreement. I promise I'll work with you, not anywhere else. Number 2, I am selling the goodwill to you. I promise that I will not compete with you for 6 months, or I will not start similar business in your area for 6 months. Is this clear? That restriction has to be reasonable. Third is restriction on existing partner. I am a partner of your firm. I have decided to be a partner. You are telling all the partners that no partner will do any other business except for the business of the firm. Fourth point is, if I am an outgoing partner. If I am an outgoing partner, the partner who is leaving the firm, we can put restriction on him with respect to a particular period, where we can tell him that after leaving the firm, you will not start the business which is similar to firm's business. You will not solicit the customers of firm. Is this clear? Is this clear? And we can put limit on 6 months, or we can put limit on him that you start the business immediately wherever you want, but not in the same area where I have the business. You can start the business anywhere you want, but not in the same area where we have the business. Is this clear to everyone? Fantastic, everyone. Okay. Now we're left with 3 questions. 3 questions are done, and the topic of Indian Contract Act is over. Next is agreement to do an impossible act in itself is void. Explain. June 2015, 3 marks. Agreement to do an impossible act is void. Explain. Everyone, Section 56 of Indian Contract Act says that agreement to do an impossible act is void. If I enter into any agreement with you and I tell you to do any impossible act, then it is void. Why it is void? I mean, come on. If I start swimming from Mumbai, Arabian Sea, and I come to Indian Ocean, and from there I come to Bay of Bengal and I reach Chennai, is it practically possible for any person to swim non-stop through that water and come all the way from Mumbai to Indian Ocean to Bay of Bengal? No, practically impossible. Your skin will, when you put your hands in water for a longer period of time, your hands become very, I don't know what you call it. It has the wrinkles on the hands. Yes, correct. Are you understanding what I'm trying to say? So such things are impossible. Can I discover treasure by magic? No, this is an impossible act. Can I ask a dead person to sing for my contract, for my program? No, I can't ask a dead person to sing for my program. Everyone, a contract to do impossible act. No, 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 no. There are 2 different things. First things first, I think I should explain this to you. Then you will understand this in a very easy way. Everyone, what is the meaning of void agreement versus void contract? Yes. Please elaborate the difference between void agreement and void contract to me. Yes. What is the difference between void agreement and void contract? Yes. What is the difference between void agreement and void contract? Who wants to tell me the difference between void agreement and void contract? Yes, void agreement is void definition, void contract is valid when it is made and later becomes void. Very good, Sagi. Very good. Void agreement. See, all agreements are not contracts, but all contracts are agreement. Agreement is a wider term. Everyone, I can make an agreement with you. Will you jump from here? I'll give you 10 lakh rupees. You say yes. This is an agreement. But will it become a contract? No. Agreement can be of anything. Agreement can be of anything. Void agreement means it is void ab initio, which means it is void from the beginning. Void from start. Void from start. Void from the beginning. Void from the beginning. Is this clear? Is this clear to everyone? So void agreement means an agreement which is void from the beginning. But what the hell is the meaning of the term void contract? Void contract means when we made the contract, it was valid. When we made the contract, it was valid. But later on, it became impossible. When we made the contract, it was valid. But later on, it became impossible. Okay, it became impossible because the person who was supposed to perform the contract has died. How can he perform? Or there is change of law. See, I am not giving an answer, I am explaining the concept to you all. Okay, void contract means a contract which means it was a contract, sorry, it was a valid contract when we made it, but later on it became impossible due to the person dying or change of law. Now, the performance of the contract was valid when we made, but later on it became void. Void agreement means it is void from the beginning. Now, if you look at the question very carefully and try to understand the language, it will become very easy and it will make sense to you. Section 56 says that agreement to do an impossible act in itself is void, but a contract to do an act which becomes impossible after the contract is made becomes void when the act becomes impossible. Okay, when the act becomes impossible. So, I did a contract to do an act. Okay, has become void. I did a contract with you to do an act. It has become void. When did it become void? When the act becomes impossible. The act becomes impossible. And the contract to do an act is becoming impossible after the making of contract. When we made the contract, it was valid. After making the contract, it has become void. Yes, no, yes. When we made the contract, it was valid. But later on, it has become void. Is this clear? Is this clear? So, if one person is promising to do something which he knows to be impossible, and the promisee does not know it to be impossible, the promiser who knows that it is impossible has to compensate the promisee for any loss that he suffered through non-performance. Is this clear to everyone, my dear students? Doubts, my dear students? question, my dear students. Any doubt, any question, any query? No doubt, no question, no query, right? Easy. Now, let us go to the next question. Contract is discharged by impossibility of performance. The contract was a valid contract, but now it cannot be performed because it has become impossible. This question was asked in June 2016 for 5 marks. The question was asked in which attempt? June 2016 for 5 marks. Now, contract is valid. Contract is valid. Has become impossible. Contract is valid. Has become impossible. Contract is valid. Has become impossible. Now, let us understand the provision one by one, step by step. Let us break it down in simple points. Okay. Now, let us understand everything in detail. Impossibility which arises later on. Impossibility came later on after forming the contract. Impossibility came later on after forming the contract. It's called post-contractual or supervening impossibility. Impossibility which came after making the contract is called post-contractual or supervening impossibility. Now, the students who have studied with me in class, they know a case of Satyabatra Ghosh versus Mugunura. Any contract which becomes impossible after it has been made is called as post-contractual impossibility or supervening impossibility. Now, how many of you who are watching the session know the case of Satyabatra Ghosh versus Mugunura? How many of you know the case law of Satyabatra Ghosh versus Mugunura? Hey, it looks like a smiley face. Yes. In Satyabatra Ghosh versus Mugunura, what happened was there was a piece of land. This piece of land belonged to Mr. A. Now, while teaching the concept, I am solving and I am also explaining a case law to you all. So it is a humble request to all the students that please pay kind attention to the case law because there is nothing like this case law. So there is a piece of land. There is a piece of land. Okay, this belongs to Mr. A. Mr. A enters into a contract to sell the plot to Mr. B. Mr. A has made a contract to sell the plot to Mr. B. This is our first point. Mr. A has entered into contract to sell the plot to Mr. B. Mr. B has paid advance token of rupees 10 lakhs. Okay, the price of this plot is 1 crore. Price of the plot is 1 crore. This is your second point. This is your first point. Okay, A is selling plot to B and B has given advance money of token rupees 10 lakhs to Mr. A. Now, before the registration of the plot, a war breaks out. A war breaks out. What breaks out? A war breaks out. Now, government of India says that we need this plot for war purpose. And once it is over, take it. Okay. So the plot belonged to whom? Mr. A. Government told him that war has broken out. We need this land. It is strategical land. We'll give it back to you once the war is over. Now Mr. A says okay. And Mr. A tells Mr. B that earlier performance was valid, but now it has become impossible. Who said this to whom? A said this to him, and he's like, take your token money. Now the question is very simple and clear, my dear students. Can Mr. A compel Mr. B to take the token money, or can Mr. B go in court and say that I want the piece of land? Because Mr. B tells in court that, my lord, I don't want the money, I want the land. Mr. A is saying that the performance of the contract has become impossible. Impossible arises subsequently after making the contract. It is called as supervening impossibility or frustration of contract. Now you tell me who will win the case. Is it Mr. A who is going to win the case, who is saying that the plot cannot be given because it has become impossible, or will Mr. B win the case, who says that he has to give me the plot? Give reason for your answer. Yes. Who will win the case, and give reason for your answer? I want reason. I don't want only answer. I want reason. I'm a man of reason. I like reasoning. Yes. Who will win the case? A or B? Yes. No answer? No woman, no cry. What, man? So I have a doubt that it is really impossible to perform. If I can say that, I don't. No, no, no. You are taking it a wrong way. I'll give you the answer. No, no, no. You'll confuse yourself if you use this logic. Wait. Everyone, A said to Mr. B that it is impossible to perform, but over here it is not permanent impossibility, it's temporary impossibility, which means once the war is over, government has told him, right, we'll give you the plot. So which means A's defense is wrong. A cannot defend the plot. A has to give the plot to Mr. B once the war is over. Now, did you understand the meaning of impossibility? Everyone, A said that the war is there. I will not be able to give the plot. The contract has become impossible to perform. It is supervening impossibility. Will A win the case? The answer is a big no. A will not win the case. A will not win the case. Everyone, listen to me. Discharge a valid contract by impossibility of performance. A valid contract will be discharged if impossibility arises after making the contract. A contract which was valid is now discharged. Why? Because impossibility is arising after making the contract. It is called as post-contractual impossibility or supervening impossibility. So a contract is discharged by supervening impossibility in the following cases. Number 1, accidental destruction of subject matter without any fault of the party. What is the meaning of this? We made a contract, there was a rare painting. We made a contract, there was a rare painting. I told you that I will sell the painting to you. But before I could sell the painting to you, the painting got burnt. Now it is accidental. It is not in anyone's hand. The painting was kept in a museum. There was an earthquake. The painting is damaged. It is destroyed. Second, change in a particular state of things. Then serious illness, death or incapacity of party, where the performance of contract depends on a skill of a person. I wanted Mr. M.F. Hussain to paint the painting of my grandfather, to paint a picture of my grandfather. M.F. Hussain is died. He died after making the contract. Another example, I asked Lata Mangeshkar, I asked any singer, A.R. Rahman, to perform for my son's birthday, my daughter's birthday, my father's birthday, my wife's birthday, my husband's birthday. I have asked A.R. Rahman to sing, but before he could sing, he dies or is seriously ill. He is on bed. Will he be able to sing? No. So the contract is valid. Now it has become impossible to perform. Change in law. Did I not tell you that? Like, let us take an example. In state of Gujarat, alcohol is banned. Let us go back in time. Imagine that I am a manufacturer of alcohol and you are a supplier of alcohol. I manufacture, I give it to you, sell it in market. I took advance money for one entire year that I will supply alcohol to you. But guess what happened? Guess what happened? Once we made the contract, after making of contract, I supplied the alcohol to you for 4 months. But because of the law, the government in the 5th month said that alcohol buying and selling is prohibited in the state of Gujarat. Now, is the performance of my part or performance of my promise going to happen? No. Why? Because government has changed the law. Now I cannot supply alcohol in the state of Gujarat. So the contract in the state of Gujarat has become void. The contract has become void. Is this clear? I'm so sorry. Something went in my eyes. Just give me a minute. Okay. Now, last but not the least, declaration of war. Trading with enemy is not allowed. You all have studied this, that if you trade with enemy, it is a void contract. Alien enemy, any agreement with alien enemy is treated as void ab initio. It is a void contract. Is this clear? Is this clear to everyone? Now, conclusion. When performance of valid contract becomes impossible due to subsequent event, the contract may be discharged by supervening impossibility. Contract is discharged by supervening impossibility. Is this clear? Doubts, my dear students? Is there any doubt? Is there any doubt, any question, any query to any of the students who is watching the session? No doubt, no question, no query. Concept is clear. Yes, doubts. No doubt. Clear? Okay. Now, distinguish between illegal agreement and void agreement. Now, you will never forget this line in your life. Promise me. Promise me that you'll never ever in your life forget this line. All void agreements are not illegal, but all, I'll change the color of all, writing practice, Selvi. Writing practice is the key for your problem. That's it. Reading is not the solution. Studying it is not the solution. Writing is the solution. All void agreements are not illegal, but all illegal agreements are void. All void agreements are not illegal, but all illegal agreements are void. All void agreements not illegal, but illegal agreements are void. What is the meaning of this? The meaning is very clear, super clear to everyone. If I do an agreement with a minor, Is it illegal? Agreement with minor, is it illegal? Is agreement with minor illegal? No, it is only void. Correct. Now, I want to sing for your father's birthday. Okay, on 31st of December. Your father is dead. Now, the contract is void, but has it become illegal? Has it become illegal? No. What is the meaning of the term illegal? Illegal means something which is prohibited by Indian Penal Code. Now, Bharatiya Nyaya Sanhita. What is the meaning of illegal? Illegal means something which is declared by law that it is illegal, or anything which is in Bharatiya Nyaya Sanhita. It is an unlawful, immoral or criminal act. So, an agreement, illegal agreement means what? Involving an unlawful, immoral or criminal act is an illegal agreement. Void agreement is something which is not enforceable by law. Void agreement is something that is not enforceable by law. What is the meaning of this? Can you enforce void agreements in court of law? No. All void agreements are void ab initio. Courts will never help you. Illegal agreement is something which is unlawful, which is immoral. It is a criminal act. Now, collateral transactions are also illegal and are not enforceable. But collateral transactions are void to a void agreement are enforceable. Now, if you don't know the meaning of this, just write me in the chat box and I will explain the meaning to you. If you don't understand the meaning of this, just write me. I will explain the meaning of this to you. Okay. Now, please focus and pay attention on screen. Okay. See. A and B enter into a contract. What is the agreement between A and B? To commit crime. Okay. Now, for this criminal activity, A is supposed to pay rupees 1 crore rupees. What is the amount that he is supposed to pay? 1 crore. To pay this 1 crore, A takes a loan from his friend C of 1 crore. Okay. Now, please tell me, is yellow color part the primary agreement? Is the yellow color part the primary agreement? Correct. And is the red color part the collateral agreement? The red color part is collateral agreement. Is the yellow color part illegal? Yellow color part is illegal. This is the collateral part. Any agreement which is illegal and any collateral agreement, this is between A and C, that I want loan, collateral agreement will also be void. Illegal agreement is void. Collateral agreement is also void. But if it is not illegal, only void agreement, then collateral will not be void. It will remain valid. Is this clear? Is this clear to everyone? Is this crystal clear to everyone? So, collateral transaction to illegal agreement are not enforceable, but collateral transaction to a void agreement are enforceable. So, parties can be punished for making illegal agreement. Just because it is a void contract does not make it a punishable offense. Offense, 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 offense. Is this clear to everyone? easy, easy. We are done with around 20 questions, 18 to 20 questions of Indian. Oh my God, you are going such a nice pace. Yes, no, yes. Doubts? No doubt, no question, no query. Life is beautiful when I am with you. Life is beautiful when I am there. Life is not beautiful when no one is there. So that's it for today. See you all tomorrow. Till then, do whatever you want to do, man. Don't trouble Mata Pita and Bharat Mata. Mamma Mia, lasagna, puppy. Bye bye. Also, remember one thing, all the best for the results. For all the students who are having their exam results tomorrow, for CS Executive as well as professionals. Okay? So, take care, everyone. See you tomorrow. Till then, bye bye. Bye 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 bye.